A very good evening, distinguished guests, ladies and gentlemen. My name is Jaya, the head of administration at the faculty, and on behalf of NUS Law, I'm extremely delighted to welcome all of you to the David Marshall Professorial Lecture. This chair was established in honor of Mr. David Marshall, who made significant contributions to the growth and development of Singapore as a preeminent criminal lawyer, a politician who became Singapore's first chief minister, and a diplomat who served as ambassador to France, Spain, Portugal, and Switzerland. Dean Chesterman has been the David Marshall Professor since August this year. This evening, Professor Chesterman will deliver his professorial lecture on All Rise for the Honourable Robot Judge, using artificial intelligence to regulate AI. The chairperson for today's lecture is the Honourable Justice Aedit Abdullah, Judge of the Supreme Court. It is my pleasure now to invite Vice Dean Research, Professor Damien Chalmers, for his welcome address. Damien, please.
Ladies and gentlemen, distinguished guests, may I echo Jaya's warm words in welcoming you and thanking you for coming today to the David Marshall Professorial Lectureship by Dean Simon Chesterman. I just have three brief tasks now. The first is to be the cinema announcement, so please just silence or turn off your mobiles. The second is the pleasure to say a few introductory words about our chair, Justice Aedit Abdullah. I had a quick look at his CV, and clearly the standout feature was that he had taught and graduated here at NUS Law, but there were many other highlights in a very distinguished career. He has been Chief Prosecutor for the AGC, both for the Economic and Crimes and Governance Unit Division and the Criminal Justice Division. He has been Special Counsel at the Monetary Authority. He has been SC since 2012. He was appointed Judicial Commissioner in 2014, and since 2017, he has been a High Court judge. Most pertinently, for the purposes of today, he is in charge of transformation and innovation in the judiciary, and he is chair of the Legal, Technology and Innovation Committee at the Singapore Academy of Law. Before I ask Justice Abdullah to replace me here at the lectern to celebrate Simon's scholarship and to benefit from Simon's scholarship, I would like for your indulgence to just do a third thing as well. Because today I think we're a little bit here also to celebrate Simon's remarkable tenure as Dean. He finishes in a month's time. And I hope after, over the next couple of months, we'll hopefully reflect a few times on the journey the law school has done in the last decade, and most importantly, on Simon's contribution to it. And I realize with remarks like this, there's a danger they're like wedding lists. There's as much what you can include and what you can exclude that you can be commented on afterwards. So I'm keeping them very general and vague, Simon. So I'm going to say three things in particular. The first goes to the students that the most important thing, the students that we've had during Simon's tenureship. In my view, as a relative newbie here at the faculty, they're some of the best undergraduates in the world, and we teach them some of the most extensive range of courses anywhere you can find in any faculty in the world. Alongside that, during Simon's tenure, the faculty has developed a JDE program, a very successful pro bono unit, among other things, and the master's program has nearly tripled in size. Secondly, during Simon's time, I think it's right to say that the faculty has become one of the central hubs for academic traffic anywhere in the world because of the 7 centres that's been established during Simon's deanship. The number of academics and researchers that pass through the faculty is really pretty unrivaled. You'd have to go to, there are very few faculties anywhere in the world that can boast not just simply the level of distinction of the visitors we get, but the sheer range and diversity. And some of these centres have not just become resources for Singapore, and it's a bit invidious pointing particular ones out, but I particularly note the Centre for Asian Legal Studies, but they've also become global resources. There really is nothing like them anywhere in the world, and I say that as a relative newcomer. Thirdly, and it's always a little bit invidious about this, saying things about this, but we've gone from being a faculty that was about between 20 and 25th in all the rankings to being in the top 10. Now, given that the rankings are done by British and American researchers, and they seem to have reserved in the top 10 6 or 7 places for US schools and 3 at least for British schools, I think that is a tribute, particularly when you look at the size of Singapore vis-à-vis either the UK or particularly the United States. It is a very unusual thing indeed, and it has allowed us to establish relationships with individuals and institutions that may otherwise not been possible. But for me, the most remarkable thing about Simon's time as Dean, and this is I see working with him day in, day out, is really the way he goes about his job. I think colleagues will all agree on this, just in terms of the sheer resilience, calmness, efficiency and purpose. And like I said, I was a dean for only 4 years with a much smaller place, and I certainly couldn't hack it for that long. So he's done all this for 10 years, day in, day out, being calm. But the thing that is, for me at least, most impressive is his courtesy. And there's 2 parts to that. There's, of course, the etiquette of how to hold the knife and fork to the chopsticks, and Simon does that very well. But there's the more profound part of the word, which goes to the civility, the caring for other people, the consideration for other people. And Simon, there are very few people I've ever met who shows the level of civility that Simon does to everyone within the faculty. And with that, I beg your indulgence, and I pass on to what we're really here to do, which is to benefit from Simon's scholarship. And I would ask Justice Abdullah to please come to the chair.
Good evening. Thank you, Professor Chalmers. It is indeed an honor to have been asked to chair this evening's lecture. The David Marshall Professorship commemorates the memory and contributions of Mr. David Marshall, who was a giant of a man, leader, and lawyer. Mr. Marshall embodied all the qualities expected of a great lawyer, and he had respect for the law and faith in the legal system. But he also understood and was sensitive to the impact of the law and its practice on all parts of society and its importance for the well-being and commonwealth of all. Down the years, the various David Marshall professors have included many eminent academics with different areas of specialization, but their common trait has been a commitment to excellence in learning, as well as service to the wider legal community. It is thus indeed appropriate and fitting that Professor Simon Chesterman has been appointed a David Marshall Professor. Professor Chesterman is, of course, well known to all present, and it would not only be unnecessary, but also superfluous for me to have to introduce him to this audience. Rather, I would like to highlight why Professor Chesterman embodies the qualities one would expect in a David Marshall Professor, and why his lecture will be seminal and important. Professor Chesterman has, in all the years I've known and worked with him, displayed an avid interest in the development of and innovation in the law. He has never been content to deal with the law as it stands, but constantly looks over the horizon to anticipate those challenges that loom and the opportunities that may be hidden in the near future. He has constantly worked to prepare the faculty and students to face these issues and challenges. And throughout it all, he has always displayed a keen sensitivity for the interests of the different stakeholders within the legal system and the needs of all those who are affected by changes and developments. His specific topic for this evening's lecture is indeed timely. The pace of technological change impacting the law and legal practice has indeed accelerated. While it may have been accurate in the past to cast the law, the courts, and the lawyers as conservative bastions, slow to change, that is not the case anymore, not here and not abroad. The need to be prepared for, to make the best use of technology is an ever-present question on all our minds. And of all the technologies in the offing, artificial intelligence is perhaps the most important and the most challenging. There are many questions thrown up by AI in the law. Some are practical, touching on what is feasible and what techniques or developments are necessary to implement AI properly. The boundaries of these are constantly being pushed back at an ever-increasing pace. Other questions, though, are philosophical and foundational, including issues of the danger of bias and the proper use of AI to replace discretion. Professor Chesterman's focus this evening brings some of these seminal and foundational questions into focus. Whether AI has a role in governance and decision-making, and what role it could play in regulating itself, are interesting and important issues that need to be probed. Professor Chesterman's speech this evening will help us start on a needed dialogue so that we can all better prepare and shape the imminent technological future. I am certain that his lecture will be an important basis of the conversation in this area for many years to come. Without further ado then, may I invite Professor Chesterman to deliver this year's David Marshall Professorship Lecture. Thank you.
Justice Abdullah, Justice Khang, Justice Coomaraswamy, distinguished guests, ladies and gentlemen, it is a great pleasure to be seeing you in person with no Zoom option at an event like this, because much as I'm interested in these ideas, I'm also particularly interested in the question and answer that will be following. And for the students in the room, I will remind you there's a class participation component to tonight's assessment. I'm also grateful to Jaya, hiding in the wings, and the people who had been saving up 3 years of floral budgets to come out of the pandemic looking green. I'm also grateful to Damien for his partnership over the years in his role as Vice Dean and the extremely kind words that he said at the start of tonight's presentation. I never had the opportunity to meet David Marshall, though I've long known of him, like many people in Singapore, by reputation. Barrister, politician, diplomat, he was born, studied and worked in a Singapore very different from the one we know today. People talk about the swamps, the disease, Japanese occupation, but perhaps even more shockingly, that Singapore lacked a law school. British policy at the time, indeed, in many of its colonies, was not to have law schools. The official reason being that such countries needed economists, agriculturalists, engineers, and so on. The unofficial reason was that lawyers make trouble. So Mr. Marshall went to England and got his law degree there, and trouble he did make, much like another English-educated Singaporean lawyer, Lee Kuan Yew. As a barrister, when he came back into practice, Mr. Marshall was extremely effective. Some would say too effective. When many years later Lee Kuan Yew abolished jury trials, among other things, he cited David Marshall's record of getting acquittals for his clients as evidence of the inadequacy of juries. As a politician, he was Singapore's first chief minister. He founded the Workers' Party and advocated for Singapore's independence from Britain. In the course of this role, he came into, there was some friction with Lee Kuan Yew, and as a result of that, arguably, he went to Paris, where he served as Singapore's ambassador to France, Portugal, Spain, and Switzerland, as we were hearing, over the course of 25 years. Despite some differences with the PAP government, countless anecdotes testify to his dedication to representing Singapore in this role and to doing so with distinguished and indeed with great courtesy. It's an extraordinary honour to hold this chair and to succeed Emeritus Professor Walter Woon, a former Attorney General and himself an ambassador for Singapore in Europe, who was its previous holder. And I'm delighted that David Marshall's son, Dr. Jonathan Marshall, as well as supporters who made the Marshall Chair possible, are here with us this evening. Part of my job as Dean of the Law School is looking after the resources of the law school, and although it's true we get very strong support from government, and we're acutely aware that our students and their parents pay fees, to aspire to being one of the very best law schools in the world while leaving no deserving student behind, to being at the cutting edge of research, we do need additional resources. So institutions like the Marshall Chair help make that possible. I'm also honoured that Justice Aedit Abdullah has agreed to chair a talk that, among other things, speculates about the abolition of his profession. Justice Abdullah grew up in a time when there was a law school in Singapore, and he graduated from NUS with first-class honours. He continued his studies in Oxford and joined the faculty, as Damien said, before being called to higher service. And as Damien highlighted, that service included many roles in the legal service, AGC, MAS, earning the status of senior counsel along the way, eventually joining the judiciary in 2014, where he now holds key roles in areas related to this, also as Damien highlighted. So in addition to a vested interest, Justice Abdullah is playing a key role in some of the transformations I'll be touching on this evening. So thank you also. But let's get on. Allow me first to paint you a picture. The judges' roles are a deep black, though subtle touches of colour complement the national emblem dominating the courtroom wall. Red symbolises the revolution, Golden stars rising over the Tiananmen Gate signify the unity of the people under the party's leadership. Until the turn of the century, judicial officers in China wore military uniforms. The Supreme People's Court sits at the apex of the legal system, but below the Communist Party. By appearance, this judge would not have even been in law school back then. Appearances can be deceiving, of course, since her generic face and simple hairstyle were actually designed by computer scientists. Let's hear what she has to say.
双方当事人及诉讼代理人经核实，符合法律规定，可以参加本次庭前会议。被告对原告提交的司法区块链证据的三性有无异议？
没有异议。
我们现在在做的其实你不能仅仅的理解于提高效率，实际上还有一个司法公正的问题。对，就这种模式，虽然说速度快了，本身也是一种公正啊，是吧？迟来的正义不是正义嘛。
This video of a pre-trial meeting in Hangzhou's internet court, released in late 2019, so before the pandemic, this was already in place, is part propaganda, part evangelism. Courts were identified as one of the areas ripe for improvement in China's new generation artificial intelligence development plan in around 2017. In a section on social governance, it called for the creation of smart courts, or 智慧法庭. This builds on moves to digitise and standardise litigation across the country, with experiments like those in Hangzhou paving the way for further advances. The avatar can handle online trade disputes, copyright cases, and e-commerce product liability claims. Hangzhou was chosen as the centre for this activity because it's the home of Alibaba, enabling integration with trading platforms like Taobao for the purpose of evidence gathering, as well as technical support. Now, online dispute resolution is not new. Anyone who's bought something online, in particular if you bought it through eBay, has long been accustomed to online dispute resolution mechanisms that enable parties to settle tens of millions of disputes annually just within eBay alone. What's interesting in the Chinese context is the extent to which this embrace of technology is permeating the court hierarchy, not just in mediating small claims, but all the way up to the Supreme Court itself. The judicial accountability system, or 司法责任制, began as a campaign to promote consistency in judgments, which seems to be a good thing. Past efforts in China had relied on reviews by superiors, but this was deemed as impractical and undermined the authority of the judge who heard the case. AI systems in China now push similar cases up to a judge prior to a decision, flagging an abnormal judgment warning if a proposed outcome departs significantly from past data. This is part of a suite of technologies that have been adopted, influenced both by the supply of technology companies in China and the demands of a complex and developing legal system. And so we were talking earlier about the role in which this could make judges' lives easier. The Wujiang district of Suzhou has trialled a one-click summary judgment process, automatically generating proposed grounds of decision complete with sentence, making the judge's job arguably a lot easier, but certainly a lot more problematic. Other courts are following suit. In Singapore, the Chief Justice, Sundaresh Menon, has said that some of these developments in China are making machine-assisted court adjudication a reality. At the same time, he noted, the use of AI within the justice system gives rise to a unique set of ethical concerns, including those related to credibility, transparency, and accountability. To this, one might add considerations of equity, since the drive towards greater automation is being dominated by deep-pocketed clients and ever closer ties to technology companies, with uncertain consequences for the future administration of justice. And in a bid to promote tonight's lecture, last week, the Chief Justice reiterated those themes in the context of sentencing in particular. Now, there's been a lot of discussion about the role of AI in sentencing in the United States over several years and Malaysia over the last couple of years. And I think quite appropriately, the Chief Justice pushed back against some of this enthusiasm, because much as we might want sentencing to be consistent and rational, that doesn't mean we should be handing it over to machines. So tonight I'm going to be focusing on whether and how AI systems could support regulation and the judicial function, in particular in the regulation of AI itself. Insofar as gaps are being revealed by the rise of machines that increasingly play an important role in our lives, in our work, in our play, that are fast, autonomous, and opaque in their activities, do new rules and new institutions need to be supplemented by new actors in the form of AI regulators and judges? So I'll start by briefly sketching out past efforts to automate the law. Though AI judges are the most provocative example, many areas of legal practice and regulation have long been seen as ripe for automation. Despite successes in simple and repetitive tasks, these efforts tended to founder because they were premised on a misconception of law as the mere application of agreed rules to establish facts. In practice, the rules are rarely so clear, and disagreement over facts explains a significant portion of legal disputes. A more promising approach has been to abandon the goal of having machines think like a lawyer and instead approach legal analysis not as the application of rules to facts, but as data. The second part of my presentation will consider this bottom-up approach to legal analytics, which reveals distinct limitations that are not technical so much as social and political. Even though AI systems are getting ever better at forecasting regulatory outcomes, embracing this across the legal system would represent a fundamental shift from making decisions to predicting them, which, as I will argue, is not the same thing. Even if regulation by AI generally were possible then, it's probably not desirable. Can a special case be made, however, for the regulation of AI systems themselves? If the objection to AI regulators and judges is their inability to appreciate the social context within which legal determinations take place, or legitimacy questions about humans having their fates determined by statistics, one response is that these kind of reservations need not apply to regulation of AI. So the third and final part of my talk will discuss briefly how systems could be made to be self-policing. As we've seen in other areas, for example, one of the virtues of AI is relative transparency, in that simulations can be run with slight variations to look for bias. And unlike humans, a machine is far more likely to admit to its errors. To the extent that they increase the transparency and human control of AI systems, these developments may be useful. But self-regulation by AI ultimately confronts similar limitations to self-regulation in the context of industry. Though helpful in establishing standards and best practices, red lines will still need to be drawn, and ultimate oversight will still need to be conducted by politically legitimate and accountable actors. And I would submit AI cannot fill that role. And if it's impermissible to outsource inherently governmental functions to fast, autonomous, and opaque machines, enforcement of that prohibition cannot itself be left to those same machines. All right, so on to automating the law. In the literature on AI and the law, an early theme was that legal practice, viewed essentially as the logical application of rules to establish facts, was a strong candidate for automation. Though initially confined to theory, in the 1980s, researchers developed prototype systems based on manually created representations of rules in machine-readable form. The enthusiasm was characteristic of the time, preceding as it did one of the AI winters that has periodically seen inflated expectations crash against reality. And as a student in the 1980s and a law clerk in the 1990s, this was obvious in terms of the potential. I mean, I was working part-time in a law firm when I remember seeing two associates being paid a couple of $100 an hour, with one reading one version of a document and the other reading along on a second document to establish that these were in fact the same document. And this was pretty obviously a candidate for automation. And that's something that would be done by machines today. At the same time, investment was getting way ahead of application. And so I'm not sure if people who were active in the 80s and 90s remember this, but there were many partners who had computers put on their desks, which were essentially $3,000 decks of cards because they were only used for playing solitaire. Subsequent decades, however, did see transformations in legal research and document management in particular. These increased lawyers' access to information and their efficiency in using and sharing it, but did not fundamentally alter their role. And this has been one of the themes in the use of technology, the difference between digitization, doing things digitally, and digitalization, which is transforming the way we do things. Even those encouraging the adoption of technology early on believed that the inability of AI to emulate human qualities limited its scope for taking on the higher function of lawyers, the role of judges in particular. And there's a quite wry footnote by David Susskind pointing out that I think in the 1980s he said, well, judges will never be replaced by lawyers. Judges will never be replaced by robots, something that he subsequently rethought his position on. As we've seen in other areas, however, emulating human methods may not be the right or the best approach for reaping the benefits of AI. In the case of autonomous vehicles, for example, no one seriously ever suggested that the way we would get to autonomous vehicles is by developing robots that would hold the wheel and deploy the pedals with feet. Rather, we have a different approach in terms of how we're trying to automate the driving function. In the same way that when the Wright brothers were looking at the invention of flight, one of their key advances was to stop emulating the behavior of birds and trying to look at aerodynamics and solve the problem that we actually had. Perhaps the Do Not Pay chatbot, which was launched in 25, was one of the first indications of what might be possible. Written by a 17-year-old Stanford student, it followed a series of rules to appeal against parking fines. It wasn't really AI, but similar technology now facilitates other simple tasks, from the making of wills to reporting suspected discrimination, yielding efficiencies as well as offering greater access to basic legal services for the wider public. And this is one of the key opportunities that I think AI does offer, at least in terms of dispute settlement, which is access to varying forms of justice. But it's also leading to a re-evaluation of what the practice of law means in the sense of a regulated profession. If a practicing certificate, and I know we've got a former president of the Law Society in the room tonight, if a practicing certificate or membership of a bar is required to offer legal advice, at what point does an automated system cross that line? So rule-based chatbots like Do Not Pay do not seem problematic. They're analogous to someone who publishes a textbook with a flowchart that guides you through certain legal forms of decision-making. And how the law may handle various hypothetical situations that would not be regarded as legal advice. But if an AI system takes in new information, analyzes it, and recommends a course of action in a manner that goes beyond the expertise of the programmer, does that become legal advice? Should it be regulated in the same manner as a lawyer? These are some of the questions raised by legal tech, a growing area of legal practice. Now, the current solution is to have a lawyer sign off on the advice, much as a partner in a law firm may approve a memo that might have been drafted by an intern or by someone else. And that was the approach accompanying another high-profile example of technology making inroads into the legal profession, when white shoe law firm in the United States, Baker and Hostetler, announced that IBM's Ross was joining its bankruptcy practice. Though routinely referred to as a robot lawyer, Ross was neither. A subscription service lacking any physical form, certainly not a humanoid one, it did not provide legal advice as such. It was, however, adept at sifting through vast numbers of documents for relevant information in support of the firm's cases. And this also reminded me of a story when I was a law student. Some of us were called in because there was a huge shipping company being bought over by another huge shipping company. And so a law firm in the mid-1990s basically needed to photocopy a room full of documents. And so we spent the entire night destapling, photocopying, and so on. And some of my peers said, "Isn't this fantastic? We're at the cutting edge of legal practice." I said, "This is a complete waste of time. This should surely be automated." And I think that speaks to some of the dilemmas in this area, what needs to be reserved as work for paid lawyers and what can be outsourced to machines or indeed outsourced to other actors. In the case of Ross Intelligence announced in December 2020 that it was shutting down operations, defeated not by the limitations of its programming or the open-textured nature of law, but by a lawsuit from competitors. Now, many lawyers long assumed that litigation would be the last part of legal practice to be automated, though my example from China in the introduction points to some inroads being made there also. Online dispute settlements have a long history, and for smaller claims in particular, have been embraced not only by online traders like eBay and PayPal, but also in the legal systems of Canada and Britain, and there are interesting discussions going on in Singapore right now. And yet the tsunami of change, long forecast by people like Richard Susskind and others, have not, or at least not yet, occurred. You can see in the history of his books, he's been banging on about this for 25 years, eventually bringing his son in 2015 to join him as a co-author. But I do think, and he would probably be the first to claim this, there is something different about the current moment and the role that technology is playing, at least in transactional lawyering. But why has law been so resistant? Why has it resisted so far? In part, it's due to institutional resistance. Lawyers have defended their domain against encroachment by accounting firms, although that's a debate going on now as well, and other actors. Some view computers as just the next horde to be repelled. As a profession, lawyers are also notoriously conservative. Though transactional lawyering must accommodate the needs of business, courtroom procedures, at least until recently, were characterised by elements both Byzantine and archaic. And it is striking how the COVID-19 pandemic forced an almost instant reassessment of information technology in the law firms and in the courtroom. Yet, much as classrooms at schools and universities, including my own, utilised video conferencing service like Zoom, however, this was really at base a change of medium rather than a transformation in which the way in which law is practiced or education is conducted. Digitisation again rather than digitalisation. A second reason, however, why the legal profession has resisted radical change and why at least parts of it, I think, will continue to do so, is less self-serving or institution-based. For it turns out that neither of the assumptions underpinning the hopes for widespread automation, that law is a contained logical system and that facts can be unambiguously established, withstands much scrutiny. A preliminary problem is that legal rules are typically expressed in natural language that may be difficult for computers to parse. Now, this is a familiar issue in linguistics. Humans often interpret language consistently, but not logically. Imagine an instruction, for example, with the following request. Please buy me a newspaper, and if the store has bananas, buy 6. Now, I assume any one of you would go out and then either come back with a newspaper or a newspaper and 6 bananas. A naive and literal interpretation, however, could lead an autonomous agent to return with 6 copies of the newspaper. A plausible interpretation, but a ridiculous one. Similarly, the difference between saying, I hunted the bear with my knife and I hunted the bear with my wife, the difference is immediately apparent to you, but requires a bit more information outside the text to make sense. Sometimes language may be inherently ambiguous. The statement that I saw the girl with the telescope might mean either that the speaker looked through a telescope or that the girl was carrying one. Every time I see this, I think that Jimmy Stewart looks extremely creepy in Rear Window, but maybe that's just me. Advances in natural language processing have overcome many of these difficulties, though statutes and case law may be more challenging than the average text. Indeed, the profession of law, the bread and butter of my graduates and of many of those people in the room, depends on the ability to charge clients for advice as to how to structure their activities to comply with the law and advocate on their behalf to enforce it in support of their interests. Now, there may be multiple plausible constructions of a given text, even a carefully drafted one. And until statutes and judgments are written in a manner that can be represented using formal logic, the authoritative text is the original one. Yet this points to a more fundamental problem, which is that many laws are not reducible to logical representation. Now, to be sure, you can argue that some may be. Road traffic laws, for example, state that exceeding a given speed limit in a certain area constitutes an offence. And many jurisdictions use speed cameras that essentially automatically record infringements and issue fines. Yet it's telling that these laws, which are the most likely that most of you will encounter in your daily activities, essentially are not taught in law school, mainly because they're so clear. Others, however, are not. The tort of negligence, for example, a first-year subject, is not representable as duty of care plus breach plus causation minus damages equals liability. It explicitly incorporates judgments based on human experience, the famous man on the Clapham omnibus, and notions of reasonableness. In other areas of law, terms such as good faith or unconscionability are notoriously difficult to define in terms that would be useful to a machine. Pretending otherwise is to delegate the interpretive task from the judge not to the machine, but to the programmer who established its parameters. And I think this is one of the reasons why there's great wariness, as I said earlier, about handing over sentencing decisions, that you might think that sentencing could be reduced to a kind of equation, but to the extent that a judge handed over that discretion to a machine or to the programming parameters, it would be an abdication of his or her responsibility. More formally, it's sometimes argued that efforts to treat the law as a logical system susceptible to automation will fail due to the necessary incompleteness of that system and indeed of all such systems. In any case, few legal theorists today would adhere to a strictly formalist position that law can or should be interpreted mechanically. Ronald Dworkin, for example, did hold that there is one correct answer to legal questions, even to the difficult ones, but he explicitly rejected the notion that this implied that this answer was reachable by a computer designed by what he said was an electronic magician. On the contrary, the difficulty in applying the law is that it is always an exercise in political morality, interpreting the law in its best light on behalf of a community in search of a justification for state coercion. Joseph Raz rejected Dworkin's view of uniquely correct solutions, arguing that judges in such cases are analogous to subordinate legislators with legal duties to enact particular rules. The positivist tradition is often seen as the most sympathetic to the automation of legal processes, but even HLA Hart held that judges must make choices where existing law fails to dictate that any decision is the correct one. As for legal realists and critical legal studies scholars who emphasise the role of judges and the influence of power on the social order, well, they would regard the question as being so ridiculous as not even to be worth taking seriously, the idea that you could outsource it to a machine. And these are some of the people most agitated about this prospect now. So what does this mean for individual judges? In his confirmation hearings before the US Senate, Chief Justice John Roberts deflected criticisms of his alleged partisanship by quipping that his job was merely to call balls and strikes. Now, his answer was disingenuous for a couple of reasons, in particular regarding the politicised nature of the court. And it's striking looking at American politics, and Americans are voting, I think, in a few hours for their Senate, the extent to which many people vote for the Senate or indeed vote for their president based not on the personal virtues of the candidate or his or her ability to represent them, but in order to get a requisite number of votes to get judges on a court. Which is a position that is hopefully going to be contained to the United States because it deeply politicises the role of judges. But Roberts was also disingenuous because he underestimated the moves to automation in Major League sport. In baseball in particular, there have been many calls for umpires to be assisted by a computerised strike zone or replaced entirely. If the role of judges was as simple as determining whether a leather-encased ball passed within a 3 square foot zone or not, then they probably should be replaced by machines. It would be both more efficient and consistent, although we see that even in sports with arguably objective answers, in tennis, in soccer, where there's great resistance to having automated judges, not because people want the wrong decisions, but because it changes the nature of the game, it takes some of the flavour out of the game, and it reduces to an artificial enterprise. Even if a law did appear clear on its face to be expressed clearly, for example, no vehicles in the park, to pick a well-known example first offered by Hart, how it is to be applied in practice may be less so. And so we move from the clarity of the rule, this seems a reasonably clear rule, to what it might actually mean in practice. So you and I might agree that it covers automobiles, but what about bicycles? What about roller skates? Toy cars? What about a stroller? What about a statue of a Second World War tank? The underlying problem is that the strength and the weakness of language is that it is open-textured, an idea traceable back to Wittgenstein. Even when there may be near universal agreement on many applications of the law, marginal cases will arise. And I'm actually curious, so who would say that no vehicles in the park, let's do a little class participation now, who would say no vehicles in the park includes you can't drive a car into the park? Okay, so keep your hand up if you would say no bicycles in the park. Okay, who would say no roller skates in the park? Okay, and no one's going to say toy cars or say that the tank is out of rules, is out of bounds. So the open-textured nature of language and law has an important connection also, though, to time. It's not just uncertain in the moment, it's helpful that it's uncertain because that means it's adaptable to the future. 20th century legislators, for example, could be forgiven for failing to contemplate whether the vehicles prohibited from entering the park included drones. The need for flexibility in applying the law to particular facts is not merely hypothetical, and I've been dealing largely in hypotheses up until now. In the late 19th century, Ronald Dworkin gives a good example of this. The New York State Court of Appeals heard a case in which the plain language of a will and the relevant legislation made it clear that the grandson of Francis B. Palmer should inherit his estate. Very clear, both the law, the will, clear answer. Small problem, was that the younger Mr. Palmer had poisoned his grandfather, which gave the judges pause. And Dworkin uses this as an example to argue that nearly universal principles of justice may require a departure even from clear textual rules. The implicit argument being, in my case at least, that if a robot was interpreting this, then that human quality might not have come out. And in this case, certainly the murderer did not get his inheritance. Perhaps the strongest illustration of the difficulty of applying laws to facts is the market for legal services, in particular litigation. If laws were clearly drafted and easily applied, let's just assume that was the case, then few disputes would actually end up in court, because rational, well-informed actors would reach the correct conclusions on their own. And then there would be no need for appellate courts, because smart judges would get it right on the first time. Now, I defer to the judges on this question, but the reason cases end up in court is only rarely because one side is objectively and obviously wrong. This is borne out in practice, assuming that potential litigants, in civil suits at least, make rational estimates of the likely outcome at trial. The individual maximising decisions of parties should mean that their success rate approaches 50%, regardless of the substantive areas of law. Now, that figure's a limit case only, approached as the standard of decision is clearer, parties' estimate of the quality of their own cases is more accurate, and the stakes on either side are of similar value. But it finds some empirical support. Now, this is not to say that the role of judge is there essentially to toss a coin, but rather to say that the legitimacy of decision comes not from merely the rightness of it, but from the rationale behind it, the reasoning, and indeed the process by which it is reached. So inherent in many of the debates over AI and legal regulation are fundamental differences not in the understanding of AI, but of law. If law is understood in a narrow, formalistic way, the blind application of rules to uncontested facts, then processing it through algorithms would make sense in the same way that it would be inefficient to have regulators or judges doing long division by hand instead of using a calculator. But to state the obvious, law is not long division. The simplest of cases aside, the regulation of behaviour and the resolution of disputes is an inherently agonistic enterprise that involves values and meaning that are necessarily contested. As Oliver Wendell Holmes famously said, the life of the law has not been logic, it has been experience. Yes, the computer scientist might respond, but experience is precisely what machine learning in the last decade or so have enabled us to replicate now. Indeed, more recent innovations reflect a shift in the approach to the law analogous to the move in AI research towards machine learning. Rather than trying to encode legal rules in fixed systems that can then be applied to sanitize facts, top-down as it were, which characterized moves in this area from the 1980s onwards, key achievements have been made more recently in analysing large amounts of data from the bottom up. This approach does not seek to answer an individual case necessarily, but to offer a prediction as to the outcome based on past experience. It represents, as Muriel Hildebrandt has observed, a shift from reason to statistics and from argumentation to simulation, or a kind of approximation of law. The turn to AI in this context has proven useful in identifying relevance for the purpose of legal research, contract review, and discovery. And many of the tools available now are really premised on the idea that getting a 90% correct solution in a fraction of the time might be worth more than a 100% correct solution if it took weeks and weeks. And increasingly, and again, I'd be interested in some of the practitioners' views, sometimes the AI systems are actually better than the junior lawyers at even identifying relevance for the purpose of legal research. But if this insight were extended to regulation and adjudication, it would fundamentally change the task from making a decision to predicting it. Rather than being part of an ongoing social process in the development of the law, such determinations are more akin to forecasting the weather. Analytics may provide more information to disputing parties and encourage the efficient resolution of disputes while reducing bias and error, but they could not be a replacement of the judicial function itself. Indeed, in some jurisdictions, the approach has been met with outright hostility. In 2019, for example, France adopted a law prohibiting the publication of data analytics that reveal or predict how particular judges decide on cases, with a maximum punishment of 5 years in prison. Now, this wasn't really for the reasons that I'm highlighting. It was actually linked primarily to personal data of judges. But it was a really striking sort of line in the sand that France, as it has on a few occasions, has tried to draw against the idea of automation changing human relations, changing what are regarded as political determinations. Though France will likely remain an outlier, at least in terms of data analytics in court, AI systems will not replace lawyers or judges in the near term. A more probable scenario is increasing use of AI systems as part of legal services, a partnership sometimes compared to the pairing of humans and machines to play advanced chess, also known as centaur or cyborg chess. And we were talking about AI systems playing chess earlier on, and there was a period when Garry Kasparov was championing this idea of a centaur league, and there was a window, quite a brief window as it happened, where humans paired with AI were the most effective at chess, but now the AI beats all of us. But you can imagine this sort of utilization of data, and we've seen it in jury trials in particular, to go back to David Marshall, where in the United States a huge amount of effort, analogous to the prediction of election results, and we'll see how accurate the polls are tomorrow, are also used to predict the decisions that certain members of juries would make. And that gaming of the jury system, I think, has also been a reason why there is a certain wariness of the legitimacy of some of those processes, insofar as they're not just enabling a proper decision to be made, but trying to shape the decision in a particular angle. So what role can AI play in this sort of in this hybrid mode? It's common to draw a distinction between technology assisting in the retrieval of information on one hand and the exercise of judgment on another. The former is analogous perhaps to the use of a calculator or the use of an index and deemed unproblematic, but the latter raises troubling questions about who exactly is exercising discretion. The problem is that when the information being retrieved goes to the heart of a decision, that distinction may be artificial. And here we can draw a comparison with automated vehicles, where there are different levels of automation. And the Society of Automotive Engineers has these levels 1 through 5. Level 1 might be things like cruise control, not something you're probably familiar with. Level 2, lane assist, where you can let go of the wheel briefly, but you must be ready to seize it at any moment. Level 3, where you can let go, but you are meant to be alert and ready to resume control of the vehicle. Level 4, where you can basically take a nap. And level 5, there might not even be a steering wheel. And what's interesting is that because of human biases, we are just innately incapable of maintaining the level of focus that we need to in order to remain ready to seize the wheel at that level 3, meaning that most automotive companies have determined that they are going to skip that level completely. And they will move probably from lane assist to when you can actually switch off completely. And some of the most famous examples of accidents happened when there was a misunderstanding about those different roles. As we've seen in other areas, reliance on opaque systems to make recommendations on matters like sentencing, as we move from areas where we might not care so much how a decision is made, like automated vehicles, through to more politically contested decisions like sentencing. These are seen or argued to be an abdication of the judicial function, not necessarily because they may be incorrect, but because they are less legitimate. More generally, automation bias raises concerns that human agency may diminish in favour of reliance on the machine. And this is the concern with the one-click judgment in Suzhou, that the first couple of judgments, the judge is likely to review it very carefully, but the more the judge becomes a mere rubber stamp, the less his or her role as a judge plays its role within the legal system and the political structure that supports that. Even for sophisticated decision makers, it can be difficult to tell where an algorithm's nudge and the accountable individual's choice begins. And we've seen this also in areas like lethal autonomous weapons, where the key line in the sand is said to be meaningful human control. The problem being that meaningful human control over what? Because as drone technology becomes much more sophisticated, it's already common that a lot of the construction, maintenance, piloting, navigation of drones are outsourced to companies, or increasingly navigation decisions outsourced to AI systems. Targeting recommendations, lines of attack are also being recommended. And so if the human's role is limited to pressing the red button that is the kill switch, there is a danger that that will be reduced to a merely formalistic rubber stamping of the enterprise. And similarly, the concern with the judicial function is if the judge is merely reduced to an approver, a sort of human over the loop, that this will actually undermine the role. For present purposes, it's sufficient to conclude that AI will continue to transform the legal profession and the role of lawyers, as it is in other industries, but hopefully at least not to replace them completely. The limits are not so much technical as inherent in the nature of law and the legitimacy accorded to it through political structures in most well-ordered societies. Now, is there, however, a special case to be made for AI playing a larger role in regulating AI itself? So the speed, autonomy, and opacity of AI systems do occasionally give rise to practical and conceptual difficulties for human regulators. In some cases, the response has been to slow them down, as in the case of high-frequency trading. The flash crash of 2010, where the New York Stock Exchange lost $1 trillion in half an hour, was due to high-frequency trading algorithms that, in theory, were operating on the same basis as the securities traders, but whereas Damien and I might be able to engage in a few sales per minute, these were engaging in tens of thousands of trades per second. And so the response has been to slow them down. In other areas, the response to AI has been to ensure the possibility of accountability through requiring that actions be attributable to traditional legal persons, typically the owner, operator, or manufacturer. And it is kind of shocking that until recently, in most jurisdictions around the world, it was unclear whether computer software was a product for the purposes of product liability. Product liability originally was defined as products, manufactured products, plus electricity, but it was not clear whether product liability would apply, for example, to an AI system. Traditionally, if you went to a store and bought a set of disks, then that was a product, but if you downloaded it, it might not be. The European Union has recently confirmed, at least, that most of the systems I'm at least talking about in this context would be regarded as product, at least for the purposes of European Union law. In still others, the response to AI and the challenges that it raises has been to call for prohibiting certain activities entirely, most prominently the use of lethal force, and the example of lethal autonomous weapons, meaningful human control is a key one there. So AI can offer a means of supporting regulation of AI, though the traditional justifications for regulation don't translate easily onto AI systems themselves. And this is the question of what are we trying to do when we're trying to regulate AI. In particular, in the absence of AI with legal personality, an argument I'm happy to have if people want to in the Q&A, but something I think would be a huge mistake. In the absence of AI having legal personality itself, the targets of regulation are not the AI systems themselves, but those who own, operate, and make those systems. That said, the unique features of AI do suggest two avenues for a form of self-regulation. First, regulatory objectives can be built into the software itself. Analogous to requirements that privacy values be incorporated into software harvesting personal data, this may be termed regulation by design, analogous to privacy by design. Secondly, AI systems allow for interrogation of mistakes and adverse outcomes in a manner not possible with traditional legal actors. You can imagine interrogating an AI to ask if it's biased. Good luck asking a human if he or she is biased. This should enable greater transparency concerning errors, but the consequences should also be different than for traditional legal persons, and I'll describe this second phenomenon as regulation by debugging. So in terms of regulation by design, the idea of incorporating law-compliant behaviour into an AI system may seem self-evident. Autonomous vehicles should comply with traffic laws, algorithms allocating social benefits or recommending loans shouldn't discriminate on the basis of sex or gender. But it's possible to go far beyond this. The notion that regulation can be achieved through design is not new, though legal scholars often focus on traditional command and control approaches. Design choices can gather information, set standards, and shape behaviour for regulatory ends. The usual tools of regulation, commands, incentives, influence, presume the need to compel or persuade human actors or their corporate proxies to do or refrain from doing certain actions. Programmable devices and systems, which include most applications of AI as I'm describing them here, offer the possibility of incorporating regulatory standards directly into their code. There are limits, however. As I've argued elsewhere, proposals analogous to Asimov's laws of robotics misconceive the nature of law and will never be a complete solution to the regulatory challenges posed by AI systems. And here I'll pause because I'm always curious how many people have actually read Asimov. It used to be almost everyone. In this kind of crowd, okay, about a third of you. So Asimov famously came up with the 3 laws of robotics, which maybe you've at least heard of, which I think misunderstand the problem of regulating AI as being both too hard and too easy. Too hard in that it really put in motion the idea that these new technologies, we need new rules. And so Asimov had his 3 laws, and from around the 2010s onwards, there was a proliferation of guides, frameworks, principles. Jung-Pil Han and I are in the process of analysing a whole swathe of these. There are literally hundreds. A couple of years ago, the Pope endorsed one. But it misunderstands the problem as being too hard in that actually most AI use cases can be covered by most laws most of the time. And you don't need to come up with entirely new rules to govern these new entities. But it also misunderstands the problem as being too easy because it seems to assume that if only you had the right set of rules, applying them would be easy, when actually application is where the devil really is in the details. Nonetheless, as a restriction on what systems can do, some kind of regulation by design does point to a promising path forward. Effective standard setting will in some cases require global rules, yet implementing those rules should not rely on state enforcement alone. To the extent possible, it would be helpful if these rules were encoded into AI systems themselves. As for the content of those rules, most would be the same that would apply to any product or service. Rather than requiring robots not to murder humans, for example, the prohibition should be against producers making devices that could do such things. Of more interest is how regulation by design might support the two areas that do suggest potential gaps: the need for human control on an ongoing basis and transparency. On human control, building in capability restrictions and a kill switch may sound like obvious design solutions. For the time being, that's true, though I've argued elsewhere again for a global agency to support a ban on the creation of uncontrollable or uncontainable AI. Projecting into the future, however, if the emergence of a superintelligence, and now we do veer into what is for the moment science fiction, if the possibility of a superintelligence ever moves from science fiction to plausible reality, such constraints like this could bring about the very evil that we're trying to prevent, and it may be more prudent to seek to instill alignment with human values instead. So this is the argument that Nick Bostrom and others have said, that if we try and guard against the superintelligence by limiting it, then that might inspire it to rebel against us from the outset. Now, this also relies on thought experiments, such as the idea, some of you may be familiar with, that a naive AI system given the wrong instructions, maybe going back to our chess example, you create an AI system that is the best, its one instruction is win as much chess as possible. One of its first conclusions, if it achieved any kind of sentience, might be that the key way to keep winning chess games is to avoid being switched off. And to do that, it's going to need to disable the off switch, need to disable the humans that might try and interfere with it. So all things we can discuss subsequently. In terms of transparency, another aspect of regulation by design is that different degrees of transparency may be appropriate depending on the type of decision or activity in question. Generally, however, AI systems should be designed to identify themselves as such and in a manner that enables identification of a legal person who is the owner, operator, or manufacturer. This is sometimes easier said than done. Many of us might think that it's a kind of human right to be told when we're engaging, for example, with a chatbot. The problem is chatbots increasingly are hybrid. They will start off with automated queries and then escalate up to a human, more complicated queries, then back down to an AI system when it resumes some measure of regularity. In addition, however, systems should at least maintain a basic audit trail of how decisions are made. And this points to the second way in which AI could assist in its own regulation, which is through enabling interrogation of its failures. Now, when one human kills another, it may give rise to a criminal prosecution and lawsuits. These raise legal questions to be resolved. When a machine kills someone, there may be an investigation of its owner, operator, or manufacturer, but with regard to the machine itself, the problem is more likely to be seen as an engineering one. Much as airplane crashes are studied using information from flight data recorders, audit trails in AI systems offer the chance to review how and why errors occurred. If these disclose culpability on the part of the owner, operator, or manufacturer, then legal remedies may follow. But the idea of prosecuting the AI system itself or punishing it itself would make no more sense than punishing a plane for its engine failure. If an AI system is deemed unsafe, it may be removed from the market. A more likely scenario is that it would be improved. Much as software is now continuously updated with patches as bugs and vulnerabilities are discovered, AI systems operating in the world should be expected to evolve in response to their environment. Market pressure will encourage such updates, but they could also be the subject of regulations or a court order. Debugging in this way satisfies the aim of regulation at far less cost. Assuming the improvements do not introduce other errors, it may also be more reliable than traditional regulatory tools if an AI system cannot be tempted once more into deviance. It also presumes, again, a degree of transparency that is unavailable in traditional regulatory settings. If one asks a human driver whether he or she ran a red light, or a human manager whether he or she discriminated on the basis of race, the answer may be unreliable. Proper audit logs should at least minimize this problem with respect to AI systems. The ability to get straight answers also points to a potential strength of such systems, which is that they could be tasked with monitoring themselves. Now, in the literature on oversight, there are two broad theories known as police patrol and fire alarm, depending on whether oversight is conducted through periodic surveys, wandering around doing the beat, or through waiting for problems to be escalated. AI offers a third possibility of self-investigation. This would be more than a regime of self-regulation, as it would not rely on the good faith of actors who have themselves incentives to defect. Provided the instructions were clear, a system could report on its compliance with rules and policies, among other things, examining its conduct for bias with a degree of candour not possible with humans. And problems disclosed in this way would also point to a need to rethink the remedies available, not as sins to be punished, but as errors to be corrected. So let's conclude by going back to our virtual Chinese courtroom. Now, after the avatar's brief interaction with the parties, after that concludes, the end part of this video, this propagandistic, evangelistic video, concludes with an interview with the Hangzhou Internet Court's very human Vice President, Ni Defeng. What we're doing now, he enthuses, you can't understand it as merely improving efficiency. It also speaks to the issue of legal justice. The faster speed is a kind of justice on its own, he says, because justice delayed is justice denied. And this desire for efficiency and consistency is driving China's push to digitize its court system with strong endorsement by government, as well as judiciary and support from industry. And it's an attractive desire. And indeed, in many parts of the world, there is a possibility that AI can lead to leapfrogging in governance techniques, analogous perhaps to the way in which mobile telephony enabled many countries to skip the stage where they had to lay out landlines for telecommunications. Though judges themselves remain, for the most part, human, even in Shanghai, Shanghai's courts are replacing law clerks with AI systems to perform basic legal research, another step in the push to modernize the judicial system through the use of technology. These debates and developments have been matched by the embrace of computational legal studies in Chinese academia as well. The past decade has seen a turn to empirical legal studies in China, more comprehensive even than we've seen in the United States, with computational methods now routinely used in articles published in the top generalist Chinese law journals. A partial explanation of the great attraction of computational approaches in theory as well as in practice is that China's embrace of the rule of law is a little bit more instrumental than its Western counterparts. Indeed, the very word for Chinese for rule of law, 法治, can either mean rule of law in the sense that we might mean it in English, or a system of laws as a homophone. Chinese judges refer to interpretation and the exercise of discretion in the context of judicial management, 裁判制度, a term without precise equivalent in the Western tradition, but routinely invoked in China with a view to unifying judicial standards. And again, I'm not suggesting that consistency in judicial determinations is a bad thing. It's clearly a good thing. But it's also reflective of the different approach to the rule of law in China. The judgments, and we were talking about these one-click judgments earlier, the judgments in the district and intermediate levels in China do tend to be short. A couple of paragraphs stating the facts, an outline of the applicable law, and responses to the parties' arguments and a decision. Nevertheless, even in China, judges have also expressed wariness about black box decision-making. In part, this is due to concerns about the accuracy of the outcomes. Initial efforts to train computers on the crime of homicide, for example, foundered because there weren't enough numbers of cases, and the examples in each and the facts in each varied so greatly that it was hard for the machines to elaborate standards and consistent determinations. But it also goes to the trust that underpins the legal system and the rule of law itself. Now, it remains to be seen whether China represents the future of regulation by AI, or its limit case. Tonight, I've argued that some of the qualities of AI systems that make them hard to regulate through traditional processes may also offer tools to regulate themselves through new ones. Regulation by design and regulation by debugging do suggest ways in which AI systems might be built to comply with the law and tasked with investigating their own biases and failings in a way that most humans would find uncomfortable or impossible. Yet there are limits to this role. Even if AI systems are more efficient and more consistent than human regulators and judges, that would not justify the handover of their powers more generally. For the authority of law depends not only on its processes in a formal sense, but in a substantive sense also. Regulation, legal decisions are not mere Turing tests in which we try to speculate whether the public can guess if the regulator or judge is a person or a robot. Legitimacy lies in the process itself, the ability to tie the exercise of discretion to a being capable of weighing uncertain values and standing behind that exercise of discretion in a politically accountable set of structures. Accepting otherwise would be to accept that legal reasoning is not a mix of doctrinal, normative, and interdisciplinary scholarship. Rather, it would come to be seen as a kind of history, the emphasis on appropriate categorization of past practice rather than participation in a forward-looking social project. And this is something that's, I think, obvious to certainly law professors, where occasionally our students ask us if we get bored teaching the same subjects over and over. And we always say we don't, because the law is always changing, partly because we have new students coming in, but because the law is an inherently ongoing enterprise. And so the idea that you would freeze it and say that machines will now look back over history and then continue making decisions as we made them in the past. Imagine if we made that decision not now, but a century ago or 2 centuries ago, when attitudes to slavery, to the position of women, to the role of race in the legal structures, to positions on sexual orientation, where all of these were frozen in time, would be a very different view of law from a forward-looking role that thinks of law as this mix of doctrinal, normative, and interdisciplinary scholarship, and inherently, as I said earlier, agonistic enterprise. As Robert H. Jackson, another US Supreme Court judge, once observed, the US Supreme Court is not final because they're infallible because they are final. Many decisions might properly, therefore, be handed over to machines, like how you get from A to B, or how you calculate long division, or complex chess games even. But the final exercise of discretion, the exercise of public control over legal processes that regulate our interactions with one another and with the world around us, should only be transferred when we're prepared to transfer political control also, when we are willing to give up the ballot box, if you like, for the Xbox. Thank you very much for your attention, and I look forward to your discussion. Thank you.
Thank you, Dean Chesterman. We now invite the Honourable Justice Abdullah to join Professor Chesterman to comment on the lecture and to take questions. Members of the audience, if you have any questions, please proceed to the aisle microphone. Please introduce yourself, and we would be grateful if you could keep your comments and questions brief. Thank you.
So that's one of the concerns. So the question was whether great experience with familiarity with AI systems, ever more sophisticated AI systems. So let me answer in a couple of ways. One is this idea of what AI will become. And here I think we're often, I was quoting Asimov earlier, or referring to Asimov earlier, I think we are sometimes prisoners of our science fiction. Science fiction has been wonderful in many areas. It forecasts things like the space shuttle and so on. But in the area of AI, I think it's completely misconceived, because it plants in our minds the idea of humanoid, human-level actors. And there's no reason why AI should be humanoid. There's a bit of ridicule going on at the moment about Elon Musk, not in the context of Twitter, but in the idea that these humanoid robots are going to be useful. But also human-level intelligence. I mean, if we ever, many people assume that AI will, if it develops, will go sort of dog-level intelligence, then average human intelligence, then Albert Einstein. But if it ever makes to dog-level intelligence, I think the game's over. It will vastly exceed ours. At the moment, there's no path there. But in terms of the reservations, I mean, there are different kinds of reservations. So one of the things, Jungpil Han and I oversee the governance pillar at AI Singapore. One of the things we're looking at there is encouraging research partly on the question of should we trust AI, but also trying to understand in what circumstances humans will responsibly trust AI. Because that can go in 2 directions. It can go in the direction of people being irrationally wary of AI, such as, for example, autonomous vehicles. Everyone's terrified of autonomous vehicles killing on the roads, and yet we will routinely get in a vehicle with someone we've never met, we know nothing about, and we trust our lives with them. Every year, 1 million people die on the roads, mostly due to driver error. There have been, I think, 6 deaths in 2021 in the United States with autonomous vehicles. So there's a kind of irrational fear there. Although having said that, I'm not getting in an autonomous vehicle till a few more million miles have been driven. But the other side is also a concern. So some of you know the Google engineer who claimed that this Lambda, essentially a natural language processing system, was sentient because it was speaking to him. And he's also been ridiculed. But I think he pointed to a really interesting phenomenon that we are almost certainly going to see, which is, I don't think we'll have robot consciousness anytime soon, But I think many people will believe we do, and they will act like we do, because humans tend to anthropomorphize. We tend to project onto things. So back to your question, I think this will lead to many people being both willing to rely on AI systems and indeed to trust AI systems ever more. And that's going to pose real political, potentially legal challenges. The way to extrapolate is to think about what's happening to map reading skills and memories. So map reading skills, now that we're all used to being able to go from point A to point B, the ability to read a map is a dying skill. The ability to memorize telephone numbers. I used to know 20 or 30 or more telephone numbers. Now I know 2 or 3 because it's a rational use of brain power. And so that's a concern that will lead to both political and legal challenges, I think, in the future.
Right, thanks. That segues, I think, nicely into the other question I have. What do you see would be the impact of AI on legal education? I can relate that one of our experiences in the courts has been that because of COVID and the way we've rolled out remote hearings, which has been well received by the profession, one of the adverse bits of feedback that we received is that Zoom hearings are not optimal for training younger lawyers because they don't get to see everyone in a holistic setting. They don't get to see the witnesses up close, how the judge really interacts in the physical courtroom and that sort of thing. So if you extrapolated that to the setting of the use of AI in the legal profession, would that mean that perhaps our younger lawyers, those who come out of law school now, are deprived of the opportunity to get into the grunge work, into the grind that's kind of necessary sometimes for trainings, a bit like Jackie Chan in the Drunken Master Kung Fu movies, where you've got to actually sweep the floor, mop, and wash the dishes before you get to learn Kung Fu and beat up people. So is that something that would be bad to lose, or have we just removed the drudgery of learning how to compare documents, how to proofread, how to assemble documents from scratch? Or are those essential skills, and how do we find the balance in an AI-dominated world? How does a young lawyer learn, basically?
Yeah, no, and there are people in the room who I know have been agonizing over this. So I'll talk about the profession, and then I'll come back to law school. In terms of the profession, I think you've highlighted one of the key challenges, which is it seems clear that a lot of the work, basically, low-end, low-risk, conceptual work is the easiest to outsource. I mean, there's a concern around the world that the tasks that are going to be automated, the people who are going to lose their jobs are going to be the manual laborers. Whereas actually, hand-eye coordination took us millions of years to develop, and it's quite hard to develop a machine that can do sort of fine activity. But the sort of stuff you can teach at an undergraduate level at a university, basic accounting, radiology, very basic legal analysis, that's one of the easier things to train a machine to do, or sort of complex mathematical functions as well. Scientific discovery, we've seen drug discovery, all sorts of recent interesting innovations. So what does that do to a profession like the legal one? That's absolutely a structural problem for law firms. I mean, and it's exacerbated, as I know you and the Chief Justice and others have commented on, it exacerbates the commercial pressures where clients are wanting, essentially the client is happy to pay for the partner, but doesn't want to pay for everything that supports the partner. And so that begs the question, well, where does the next partner come from 5 or 10 years from now? So back to my example, sort of complaining about having to photocopy a room full of documents. Okay, I don't think that was great legal training. But really low-end legal research and, as you say, shadowing work, seeing how things operate, I think that is a key part of training. And unless the profession structures its fees and unless clients are willing to embrace that, then you can have one generation of partners, but no way of repeating that. So what happens in law school? So law school, we're introducing a new compulsory law and technology module. So the students who enrolled in August 2022 will have to do that. And we're trying to do 2 things there. We're trying to teach them the sort of law of technology, so the rules governing these new things like autonomous vehicles, but also the technology of law, how technology will change the profession. And that's always been a part of legal education. So okay, hands up who's ever had to change a loose leaf service or update a loose leaf service. Sort of a dying breed, I'm right on the cusp. So I did, and then we got away with it. We did away with it while I was at law school, and there were a bunch of puzzled faces. So these are systems where instead of the machine just automatically updating on the net, you got a regular sort of delivery of papers that you would then slide into these folders. So you need to be able to do legal research, and that will change all the time. And one of the things we push back against at the university is the complaint by partners in law firms, hiring partners saying, why don't you teach your students the skills that they'll need on day one so they can make money for me? And our response is, well, we need to teach them skills that will also be useful in year 10, more basic critical analytical skills. So we're trying to encourage the flexibility of our students, and to encourage them to see opportunities in this world, encourage them through doing things like law and technology to ideally not just survive but thrive in this new environment. But the reality is possibly few of them will be traditional lawyers. Some will become allied legal professionals. Some will go on to legal technology companies. And that's why what we do at law school now is not just have moots. We continue to have moots, mock trials, but we also have hackathons. We have opportunities for students to engage. Because the reality is those students not only will go out into a changed profession, often they're more attuned to the changing technologies than the law professors are.
Right, thank you. If I could now invite questions from the floor. Anyone? You've got the David Marshall Professor here.
Or comments. There's a lot of experience
or
in the room.
comments, yes, are free. Rajesh? Members of the Law Society, eminent lawyers here, technologists.
Or judges who would like to go and sit back on a beach and just press one click for a judgment.
Thank you. Thank you first for your presentation, for your talk, Simon. I want to go back to one of the things that Justice Abdullah said right in his introductory comments, and then to something that you were talking about near the end, at the last part of your talk. And that is about this question of discretion. You gave the example of that famous case, the Palmer case, Riggs and Palmer. That decision was actually a split decision of the court, as you know. The majority decided that the grandson who murdered his grandfather should not get the inheritance, but there was a dissenting judgment. In, I think it's The Merchant of Venice, there's that famous line that, mercy seasons justice. But in Riggs and Palmer, it was almost like justice having to season any mercy that might be there. And that seems to me to be one of the big challenges. How can we get, because at the end of your talk you mentioned, the political context, the accountability that would have to come. Do you see a way of using AI successfully to address that? Or is that something that is going to have to be left with the human judges?
Yeah, I mean, two responses. One is, a topic I've thought about is lethal autonomous weapons. Why have a ban on lethal autonomous weapons? And occasionally, and I support a ban on lethal autonomous weapons, at least maintaining meaningful human control. Why? So some people have argued it's because, well, the battlefield's so complex, they'll make the wrong decision, they'll kill the wrong people, determining who's a civilian, who's a combatant, what is military necessity is very complex. That's a terrible argument, because the machines are getting better and better at that kind of discrimination. Actually, most war crimes don't happen by accident. They happen because people are racist, they're sexist, they behave badly, they get angry, they're tired, all things you can control with machines. So the reason for maintaining meaningful human control isn't because the humans make better decisions. It's because you should have a human that grapples with that decision. A life and death decision should be a difficult one. And there should be a person who can be then held to account for that decision, rather than saying, well, the machine made it. And that's linked with the sort of implicit question about mercy, and I'll broaden even further to ethics. So there have been these sort of grossly overstated claims that you could have ethics as a service. You could outsource your basically we'll feed in all of human history, feed in all of philosophy, and then the Delphi, I think there's actually a machine called Delphi, a program called Delphi, will tell you the ethical answer. And this, a bit like my description of law, it misunderstands the problem. The reason we have ethical disagreements isn't because people are stupid. Well, some people are not bright, but the reason we disagree about ethics is because they're inherently unanswerable questions. And so, as I said, like with the idea that if you got a machine to take over, and make decisions based on how humans had made decisions in the past, that would freeze things. Even if it extrapolated into the future, it would assume that there is an objective answer. And here I am kind of interested in, judges, I know there's an evolution, having talked with judges, the first time they get overruled on appeal is very irritating, but you have to be philosophical about it in the same way that, we make decisions in any organisation, and there has to be a final decision. But the legitimacy of the decision is not simply that it's right. You hope it's not wrong, but the legitimacy of at least some decisions, not all decisions, the legitimacy of some decisions, and in particular where it goes to ethics, where it goes to rights and liberties of individuals, obligations of individuals. There are better and worse decisions, but the legitimacy of the decision at least partly comes from the process by which it's reached, and that's where the machines fall down.
Yeah, if I could add to that, although I'm not actually the speaker this evening, I think one of the interesting tensions we've had in the courts recently in relation to sentencing, and you may have seen this, was we've had a line of cases which advocated greater certainty for everyone by postulating graphical representations of these sentencing options. And yes, it provided certainty for the parties and their legal advisors, and certainly for the judge looking at it, lower court judge wondering where in the graph you should plot the X and Y and see where the appropriate sentence would be. But many of us were actually quite uncomfortable with that kind of approach, because while it might be good for the parties, it gives them certainty, it would seem to sacrifice consistency at the expense of appropriateness and fairness, and there was a kind of instinctive reaction to that, and we've actually moved away from that kind of approach. We would rather keep some ambiguity and uncertainty, which may be of small comfort to the person who might be accused of the crime, who wants to know exactly what he or she is going to get, but actually affords the decision maker, the judge, the ability to factor in other things in the exercise of his or her discretion and to fulfill that constitutional function of exercising what is really it is a political power. It is something vested in the judge by the state to impose punishment of a certain degree. So it is a tension we have between consistency on the one hand and what might be called appropriateness or fairness on the other. What would you think? How would you think that should factor in a debate on AI and the use of AI?
No, I think that's exactly one of the problems, that if the judicial function is reduced essentially to a box-ticking exercise, it becomes either artificial or is subject to gaming. So either you tick the boxes and then you say, well, that's just the answer, or you find a way of avoiding ticking the boxes. And if I can pick a slightly controversial example perhaps, I think that's one of the reasons why there were so many reservations about the mandatory death penalty in Singapore, where it shifted discretion away from the judge. So once the judge made a determination that the person was knowingly in possession of 15 grams of heroin, then it switched the burden of proof and so on. But that just pushed the discretion earlier, leading to several prosecutions of people with 14.99 grams of heroin, for example. So I think there's an inherent wariness of taking that discretion away from judges, and AI systems would run that risk. So we've seen in the Compass litigation that some of you might have followed in Wisconsin, Wisconsin was using Compass, essentially a predictive algorithm that estimated the chances of someone being a repeat offender, and this led to a risk assessment. And the conclusion there was that the decision was ultimately upheld, even though the judge appeared to have relied on this system, because he didn't rely exclusively on the system. He had other reasons why he agreed with the system. And that's one of the reservations, that you're not entirely clear the extent to which that's being candid. But in theory, again, it was maybe also like the AI system that produces something that the legal partner then signs off on.
All right, thank you. Any other questions from the floor? Right, thank you.
Hi, Dean. My name is Lance, Global Head of Privacy with Prudential. So my question is it preemptive to regulate AI when the technology itself is uncertain and unstable? Many of my AI engineers and data scientists corrected me when I used the terminology of AI and say that it's simply machine learning. So should we start with the easier regulation of machine learning before we move on to the harder topics of AI? On the same note, shouldn't we be looking at machine learning in helping the judiciary to improve their decision-making process, such as the analysis of evidence, rather than looking at using AI to replace judiciary? Thank you.
Thanks. So this is the larger question of regulating AI, and I broadly agree that regulating AI is not the right kind of question. I tend to think about regulating use cases of AI. We don't normally regulate methods. To say regulate machine learning, it would be a bit like regulating statistics. I mean, a lot of machine learning is basically regression analyses and very, very complicated statistics. Nothing problematic necessarily in that, but particular use cases are. And in the book, I kind of go through different reasons why you would regulate, and reducing it to sort of 30 seconds, there are sort of 3 reasons you regulate in different ways. One, sometimes you just want things to be safe. That's the product liability argument. So autonomous vehicles, we just want them to be safe. Rules should make them safe. Sometimes, though, you want some decisions to be made by humans and not by machines. And that's the lethal autonomous weapons example. You want that to be in the hands of a human. And sometimes you want it to be made by a particular human. And that's the argument I would make about judges. And then in terms of the second part of the question was so, I mean, that's at the moment, one of the interesting things, so this has gone further in medicine than in law. In the practice of medicine, if a doctor uses a complex algorithm, I believe this is true, I'm happy to be corrected, if a doctor uses a complex algorithm in the course of a treatment, at the moment, that's treated, as long as it's not a physical device, that's not regulated in most jurisdictions in the way that a medical device. So if I'm operating on Aedit here, and I use some new tool, this tool has to be regulated. But if I use any computer program, it's the equivalent of me Googling for information. Now, the problem there is, and the same problem would apply to judges, as that becomes more sophisticated, as it's not sort of looking up information, but actually getting recommendations. If I don't understand the basis for that recommendation, both for a doctor and for a judge, the whole sort of accountability structure starts to break down, because medical law is premised on patient autonomy, doctor-patient relationship. But if the doctor can't explain to the patient can't understand the nature of the treatment, then that's a real problem. And I think it would be all the more in the judiciary. I mean, if you were doing legal research and you couldn't understand, because it's so complex, the nature of the research, but it predicted a result, and you say, well, okay, it looks right to me, I assume that would give you reservations.
Yes, I guess it would, but it is something we are at the early stages of exploring, considering the use of AI to help the judge not just do legal research, but to trawl through documents, the evidence, the transcripts, to pick up things that might be useful to the judge, whether it's in terms of consistency or relevance to the case and that sort of thing. We're very far off from getting to a point where we need to think about or to really test the veracity and accuracy of what's produced. So that's when we get to that point, I'm quite sure we're going to have a dialogue with you, but it is something that's being explored, and I'm sure many other jurisdictions are doing the same thing, and I'm sure many law firms are doing similar things in terms of preparation of submissions and collation of documents. I think that's as you've alluded to, the next big frontier, with not just AI in transactional law, but AI in litigation assistance, judicial assistance in a very big way. But last minute or so, yes, thank you.
Thank you very much, Professor Chesterman. My name is Gautam Narasimhan. I'm a transactional lawyer in Allen & Overy. It's an international law firm. And it was a very, very interesting 1.5 hours. I don't know the last time I didn't check my email or my WhatsApp, so thank you for that. I have one observation and one question. I'll keep it brief. I mean, and again, pardon me if I'm going to be very simplistic about this, but you have a value-based objection to AI in this context, it seems to me. So when you were talking about sort of discretion going away and that being automated, I get that. But I guess some of the other points I would just question. One was you used the example of no vehicles in the park. And you came up with those questions around, does a World War II tank constitute a vehicle? The reality is, I think we, as a civilizational issue across probably every society, we've moved to, I can't imagine a country that does not have huge amount of volumes of legal regulation which clarify as things go on, the minutiae of specific details. So I wonder if there's a confusion around whether we're talking about, the objection is to AI in judiciary as opposed to the power of regulation, because I don't think anyone would give away the power of regulating, the legislative power to AI. So I do think that, and the point was also made around, as things evolve, regulations do catch up. That's why they grow so voluminous, that I think regulations can clarify, in which case AI in itself shouldn't be a reason why, we shouldn't be using judiciary through AI. But I also look at the value-based issue, which you addressed in passing in the end, which was justice delayed in many parts of the world is justice denied. And I was sort of looking up, in India, 20% of judicial posts are vacant. AI is clearly a society-based value proposition in some of the developing parts of the world. So I think that's something that I would just balance against sort of the worry of giving away discretion. But shouldn't we look at this, and this is my question, shouldn't we look at this as actually an opportunity for human discretion to evolve? Because if you look at what AI presents is, like you rightly said, a number of things can be automated. Sort of the low value disputes, potentially parking violations can be automated. But there's always a higher quality of disputes which can't be, because, for instance, criminal law in its entirety may not be, automated. So isn't this an opportunity similar to how manufacturing moved, there's a lot of it which got automated, but then human society has evolved to high quality pursuits. Isn't this an opportunity for judicial imagination also to evolve to a higher pursuit, where some of it gets automated and the higher, the appeals are still with the individual? Sorry, it went longer than I thought it would, but.
No, it's a fascinating, a couple of questions in there. And you're absolutely right, there is an opportunity. And I'm not, well, I suppose I'm an AI skeptic, but I'm not anti-AI by any stretch. I think there's enormous potential for AI to transform society. Part of the work we're doing in AI Singapore is trying to work out how and in what circumstances people will rely on AI responsibly. The danger, if you like, is that you could end up with a kind of multi-tier justice system. And you could easily imagine a very instrumental interpretation of the law, and I've kind of alluding to that with regard to China, that if you think of the function of law as just being managing disputes efficiently, then yes, AI has a great role to play. And I think India is a good example, not just the number of judicial posts that are unfilled, there's the huge backlog of cases, millions of cases, I think, backlogged. But against that, you've also got an incredibly dynamic, politically active Supreme Court, which could not be replaced by AI, at least certainly not the way it operates currently. And so you have this tension. And at the heart of it is what we think of the rule of law, because the rule of law is ultimately the epitome of anthropocentrism, of putting humanity at the center of the world, because humans come up with rules and we apply rules to other humans. And among the speculation about roles for AI is that you could break that cycle. And again, stepping into this sort of science fiction, if AI were treated as a person or it had similar qualities to a human, why would we exclude it? Now, we've already had those debates, and we already have arguably sentient animals, monkeys, dolphins, whales, that are subservient to us. Why? Because we make the rules. And these are political judgments. They're not just value judgments. These are political, historical. This is inherent in the evolution of human society. Now, what is going to happen projecting sort of 10, 20, 30, 40, 50 years into the future? I don't know, obviously. But although I think you're absolutely right with regard to dispute settlement, and that's why small claims, online disputes, the role of AI in mediating between people, encouraging them to agree to a dispute, that's, I think, pretty unproblematic. But as you get more and more to the exercise of discretion, that's where I think we should be very reluctant to hand over that power to anyone. And the thought experiment I give you is, okay, if you had a company that came to India, for example, since we were talking about India, and said, okay, I can solve all your disputes for you, but you've just got to take our decisions. Would any country be willing to outsource its decisions like that? And if the answer is no, then why would you outsource it to a machine? Or how would you guard the legitimacy of the decision-making process? That's the dilemma. But I don't really have a full answer to it tonight.
Thank you. And the last question of the evening.
Thank you, Prof. Chesterman. So I am Xu Dong. I'm a student from PhD student from School of Computing. So I'll actually ask a little bit technical question. So my question is there a space for randomized or uncertainty in decision making in automated legal decision making? I'm asking because uncertainty and randomized decision making, like from the technical side, is actually a valuable component in AI systems. And I can actually give two examples. One is the law as a code-based approach. So starting from the large volume of legal cases to a AI system is actually a accumulation of random steps you take from the random state. So it ends up in a random product. And this is, I'm thinking, unavoidably a randomization in this decision making. Another example is in a simple decision, maybe you are interpreting the final score as a deterministic score, but you can also interpret it as a probability. And that would be actually valuable from more of a technical side, but is there a room for those randomization from a legal perspective? And that's it.
So I suspect the judges would say, no, judges make the right decision for the right case at the right time. The problem is if you actually analyze, so this has been done in America, there are kind of horrific studies that show biases on the part of judges. We often talk about bias on the part of AI. I think that's misunderstanding the problem. AI is quite good at revealing our biases because of the training data that shows bias. But there are courts in the United States that have been studied where, I forget the exact, like if you are appearing before a judge, you're going to get a longer sentence if his or her football team lost that weekend. You're better off appearing in the morning than in the afternoon, before a certain case rather than after a different case. There are all sorts of ways in which there is a danger in this kind of analysis that we actually hold AI to a higher standard than we hold humans. I mean, every time Justice Abdullah makes a decision, he writes the reasons for that decision. We don't require him to subject himself to an fMRI to analyse why his brain actually made that decision. But in terms of the randomness, I would need to think more about the kind of technical side of it, but I think it's a really interesting question, and it goes to the uncertainty of cases. And maybe I'll throw this as a last thing to Justice Abdullah. As I said, rational parties, assuming rationality on the part of the law firms, on the part of the clients, two parties are only going to appear before Justice Abdullah in a big case if they've got well-resourced, smart people working on both sides. They're only going to appear if they both rationally think they're going to win. But they can't both be right. And so it falls to people like Justice Abdullah to make the determination who's right and who's wrong. And they do it in a reasoned and justifiable way. But I don't know, what are your reflections on the extent to which randomness factors in all of this?
Well, we wouldn't want to say that our decisions are ever randomized in any way, but I think the fact that we have to give reasoned grounds and that the reasoned grounds are scrutinized by the lawyers as well as the appellate courts does constrain the space that we're able to operate in. Although that makes you think immediately of the AI like the GPT kind of things where you can actually create narratives that seem quite believable, almost human-like in many ways. And I think that will be interesting. You could have randomized decisions, but with seemingly plausible reasons being given, and it might be that it may not be any different from the kind of decisions that we come up with, and probably more readable and more succinct and concise and possibly more learned. I mean, I can't say, but that will, I think, leave us with good food for thought, and I think that will be a good point for us to head over to the compare. Thank you.
Thank you, Judge. Thank you, Simon. So now we have come to the end of the lecture. May I now invite Honourable Justice Vinodh Coomaraswamy, Honourable Justice Khang Chau, Dr. Jonathan Marshall, and Professor Chalmers to join Dean Chesterman and the Honourable Justice Abdullah on stage for a group photo. While that is happening, we would like to invite all of you to join us at the dinner reception just outside the auditorium. For those claiming CPD points, please remember to sign out outside the auditorium at the same stations that you signed in. We thank all of you and wish you a good night and a wonderful week ahead. Thank you so much.